in Texas since 2003. I've worked in a variety of practice areas, including family law, civil litigation, some time in consumer and business bankruptcy, and then time with the oil and gas company in Fort Worth. While I was over in Fort Worth, it's the oil and gas company, not related to oil and gas, but I was diagnosed with cancer in 2010. And about early 2012, I had to step away from my job, and it really it caused me to have to just look at my own life, look at my own mortality, to deal with that, and to just consider what would happen if I wasn't there, or if I was incapacitated, something like that. And so it just got me more intrigued into working in the estate planning area. And it's an area where I love helping people, and I find a lot of fulfillment in it. And I just want to share that with you and say that I've been through some of the hurdles, and I speak from experience and not having a plan, even though I could type one up myself and prepare it, and then coming to a point where I knew I needed a plan. So I mentioned a form as we go through this webinar, and you should find it in the chat box, in the chat area. If you click on chat, it should be at both the top and the bottom. There should be a link to it. And I'm going to refer to that as we go through this webinar. I'm going to go ahead and get started so I don't waste anyone's time. When we are doing estate planning, we're not really doing that for ourselves as much as we're doing it for those that we love. And so there's who is this for in your life? Well, I thought I would share who it was for in my life. And this is my lovely wife of 34 years. And I have 2 adult daughters with 2 son-in-laws, and I have 3 little grandsons. And that's the who in my life. So you'll need to answer this question as to who's the who in your life. I'm sure you don't want to leave a mess for the people you love, and you want to ensure that what you do leave is full of clarity, love, and care. You might think about who this planning is going to help in your life. So who is your who? And before we begin, I have a question for you. What brought you here tonight? Anything significant that brought you here? Perhaps did you come here to have the total assurance and comfort of knowing your family would be taken care of and know what to do if something happens to you? Maybe you came here for the peace of mind of just knowing what would happen to your assets at your death. You might have come here to find out how to make sure your family doesn't pay unnecessary estate taxes. No one wants to pay the government more than we have to. They already get enough from us. Or maybe you came here to make sure you'd be taken care of in the best way possible, with the best decisions made for you if you became incapacitated. We never know when a car wreck or injury or illness might take us out. So it's something we need to plan for. If you came here for any of those reasons, you're in the right place. Today you'll learn what you need to do to have the peace of mind of knowing you've made the right decisions for yourself and your family during your lifetime, so that at your incapacity or death, it will be as easy as possible for the people you love the most. But the real reason I imagine you came is because you really care about those people in your life. So you might take a moment right now and just think about the names of the people you're doing this planning for, or that you're educating yourself for. Who will come forward to handle things for you when something happens? And by that, I don't mean who do you want to come forward, but based on your current plan, who would it be on a practical level, based on where you live, those who live near you, who would be the first on the scene? If you don't have a plan in place for your own incapacity and want one, there's a box you can check on that worksheet I reference. Click the link and you can check a box there, and you can just kind of follow along. No worries, till you get to the end and hit submit, nothing comes back to me. So now let's talk about the estate plan you already do have. Either you've created a set of documents already, or the state has a plan for you. Either way, there is a plan for what happens when you become incapacitated or when you die. It just may not be what you want. We'll look at that today so you're clear. One way or another, you're going to leave today with some clarity about your next steps for getting your affairs in order for yourself and the people you love. Most estate plans, whether you do it yourself online or do it with a lawyer, are about planning for death. The last time I checked, the Texas Department of Unclaimed Funds was holding $8 billion of overlooked assets, unclaimed funds. That's why it's so important to have a financial inventory, and we will help you put one together so nothing gets lost to the state. We do things a little different than other attorneys. Our planning is not just about planning for death and putting in place a set of documents that you'll never look at again. Instead, we're helping you plan for life. We're guiding you through a process of educating you to help you get more financially organized than you ever have been before, so none of your assets are lost to the state or to unnecessary court processes. And understanding your unique family dynamics and your budget, so we can help you choose the right plan for you, and then making sure that plan works throughout your life so we can be there for your loved ones when you can't be. So let's review the state's plan for you. If you have no estate plan and you become incapacitated or die, the state does have a plan for you, and it's called going to court, so a judge can appoint someone to make decisions for you and or give your family access to your assets or direct where your assets should go. This court process is called guardianship if you're incapacitated, or probate if you have died. Both of them take place in the probate court, but the court decides where your money goes, and it might not be to whom you choose or in the amount you would choose. Court is costly. There's attorney's fees and executor's fees, appraiser's fees, court filing fees, bond premiums for the executor. You have to deal with creditor claims. And fairly simple disagreements in court can cost tens of thousands in attorney's fees. And all that comes out of your estate. So that's money that's diminished from what you would want to pass on to your loved ones. These fees can be avoided basically with just a few $1,000s spent on a basic foundational estate plan. The The court process is also totally public, meaning anyone can go down to the courthouse and pull up your court records to see what you own and who is getting it. Right here is the will of Jackie Kennedy Onassis. Would you like to see John Lennon's will? What about JFK Jr.? I have one for you, Babe Ruth. Another here is Jerry Garcia. You can, because they all went through the court process. Look them up online and you'll find them. Okay, my point here is that your will becomes public, and a will has to go through probate to be legally effective. So then it becomes public. For some people, the way they choose to distribute the property at death is a real personal and confidential decision they make, and it's private. But with probate, your will is now public. When a will enters probate, it puts all of the creditors out there on notice that your loved ones will be receiving money. The only plan that is private, avoids probate, ensures your children receive your assets when you want and how you want, and can save your estate substantial taxes is a properly funded trust. But we'll talk about that in a few minutes. If you go through probate, then worst of all, your children would be entitled to all of your assets outright without any restrictions at age 18. My mentor's husband received about $50,000 when he was 18. Then another $150,000 when he was 21. As a result, he didn't graduate from college until he was over 30 years old, and he never really learned to support himself financially. Having a lot of money fall in the lap of a young adult can really mess with their drive to accomplish things. So if you have minor children at home and you want to make sure that they do not receive what you're leaving behind at age 18, there's a place where you can check that on the worksheet. Also, you may want to ensure that your kids receive their inheritance protected from lawsuits, future creditors, or even a future divorce. For example, when the same mentor first got married and her dad died, he left her a small inheritance of $50,000 because it came outright to her and she didn't know how to keep it separate, as most people don't. When she got divorced, her husband got half of it. But if her dad had left her that money in a protected trust, she could have used it to invest in a business or real estate and kept all of it when she got divorced. There's a place to check on the form as well if you want to ensure your children's inheritance is protected from lawsuits, creditors, and future divorce, no matter what age they are. Before we move on from talking about your kids, if you do have minor kids at home, I want to tell you two quick stories that might illustrate how your kids are at risk, even if you've already named them as named guardians for them in a will. If you have not named guardians at all, as 65% of parents haven't, and something happens to them, the choice about who raises your kids will be left to a judge to decide, just based on state statute. Several years ago, though, there was a family, the Barber family, 2 parents, 3 sons. They went on vacation to Arizona. They were from California. Tragically, while they were traveling, they had a car accident and both parents were killed. Thankfully, the 3 boys lived, and when the authorities finally found a family member to pick them up, they found one of the sisters of the mom, and that sister decided that she should get custody of the kids and their money. And then she prevented them from seeing any of the other family members. So after more than $100,000 of court costs and attorney's fees, and nearly a year of litigation and a huge family fight, a judge decided that a different sister should raise the boys. But the judge appointed a financial guardian over the boy's inheritance, charging $100 an hour for his time. So once the boys do reach 18, they'll get whatever was in there, but they'll get it all outright when they turn 18. If you want to ensure that the people you choose raise your kids in the way you want, no matter what, check on that worksheet. I need a kids protection plan. Even if you have a will naming guardians, your kids could be at risk. One of my colleagues realized this when she was out to dinner with her husband and her baby daughter was home with her 16-year-old babysitter. She realized that she had named guardians, but they all lived across the country and no one would be able to find her will anyway. At that point, she realized that the authorities would have no choice but to take her daughter out of her home into the care of strangers until they could find her will, locate her named guardians, and place the children with them. But during that limbo period, they would be with strangers and with CPS. A kids protection plan provides advance notice to all of these parties that you would name as temporary guardians. You get a wallet-sized card, so if you can't communicate, the first responders can pull the card out and they can start calling numbers in order, 1 through 4 or 1 through 3. A kids protection plan would have prevented this kind of issue in many cases. So there's another reason that you may want to check on that kids protection plan box on the form. Now we've talked a bit about what would happen to your kids if you have minor kids, and to your financial assets if you become incapacitated during your lifetime or when you die. But what happens to you if you become incapacitated? A real quick story about Terry Schiavo. Back in 1990, Terry, 27-year-old wife, went into cardiac arrest and suffered severe brain damage and was in a permanent vegetative state. Well, her husband's argument was that she never wanted to be kept alive with artificial nutrition in that condition. And as you'd guess, her parents argued the opposite, hoping that she would come back. Sadly, that started in 1990, and that case went all the way to 2005 when a judge finally ruled that the husband was entitled to remove the feeding tube. Terry then died at age 41, but not after legal fees of near $1 million. A lot of that paid by different private or nonprofit groups advocating either for the ability to die with dignity or, protect the life. These terrible kind of events could have been avoided simply if Terry executed one simple document, though, had it in writing, then it had been clear to all parties what she wanted. I'm sure many of you have executed such a document, but I can guarantee you that for many, it's out of date, may not work when you need it, and it's unlikely to be comprehensive enough to provide detailed guidance on how you want to be cared for in the event you become incapacitated. If you want to make sure your wishes are comprehensive and honored at your incapacity, if you have specific wishes for how you would want medical decisions made for you, again, mark that worksheet where it says I need a plan for my incapacity. Many people think they can avoid all of this by either owning property jointly, designating a beneficiary for their assets, or signing a will. Joint ownership has many problems. In Texas, you need some form of probate to clear a deceased spouse from community property. That's any property acquired during marriage. Doesn't really matter whose name's on the deed. Some people just give the property to their children to bypass probate. While this does avoid probate, it causes some unexpected problems. It can cause the children to incur some capital gains taxes that maybe were never contemplated. It also puts that asset at risk if the children are sued. All of us have the potential to inadvertently, accidentally have a car accident, injure or kill someone, and have a very large judgment against us. And if your kids' names are on the property or maybe a bank account, all of a sudden that's fair game for that judgment creditor. You can designate beneficiaries on some assets, but overall, that's not really a comprehensive plan. And as we talked about, just signing a will won't work either, because wills got to go to the probate. Having a trust without properly transferring assets to the trust also doesn't work. Many of these online companies that offer trust plans, they don't really cover this, and they leave people thinking as long as I list it on an exhibit inside the trust, then it's covered, only to find out later that all that really covered was personal property, like the furniture and clothing, things like that. Anything that is registered or has a deed actually has to be conveyed into the trust. The only way to keep your family out of court, either in the event of your death or incapacity, is to have a fully funded living trust. This means that you've got a trust prepared that is properly custom drafted for your family to say exactly what you want to happen to your assets in the event of your incapacity or death. And all of your assets are owned in the name of your trust. If you already have a trust, chances are it's not been updated since you created it, and it's likely out of date because life changes, the laws change, and your assets have probably changed. It's also very possible that your assets never even got properly conveyed into the trust. I see this on a recurring basis, whether prepared by other attorneys or do-it-yourself plans. I recently reviewed a trust prepared for my client in Arizona after his wife passed. They lived in Texas and traveled to Arizona back and forth throughout the year. While they were in Arizona, they had a trust created for the sole purpose of holding this piece of real estate. And they spent several $1,000s to pay an attorney to handle this. I had the unfortunate job of explaining to him that it was never deeded to the trust, even though there's a reference to it. It was never properly conveyed to the trust. Therefore, it's going to pass as though the trust never existed. And you have some really expensive paper, basically. And you would think sometimes that that's attorney malpractice, maybe, but I don't know the situation there. The client is actually 90 years old. And so I don't know. I've seen many cases where trusts are created and clients are given, honestly, a pile of instructions on what they need to do next. And they work their way through the legalese and get about a quarter of the way through it and give up and just say, well, I just pray the attorney took care of everything. If you work with us, you will know what we transfer and what you've chosen to transfer. And it'll be on the financial inventory that we prepare, the two of us prepare. When you create a trust, you also get the choice to distribute assets to your heirs how you decide. Many a times they're staggered. The common one I see many times is 1/3 at 25, one half at age 30, and then the balance at age 35. I would probably argue that you ought to bump those up about 10 years because I've seen too many disasters where young adults have come into too much money and didn't know how to handle it. So let me ask you this question. How many of you would like to own assets that creditors can never touch? They will never be subject to estate taxes and can never be taken away in the event of a lawsuit or divorce. Yes, of course, I'm guessing all would like that. Well, now what if I said I could give you all of this, but you couldn't control those assets? Now it becomes a little less interesting, and you're less interested in doing it, right? Well, in our living trust, you can give your children assets that can never be touched by creditors, will never be subject to estate tax, and can never be taken away in the event of a divorce. And you can give them complete control. These are some cutting edge techniques that only the most knowledgeable estate planning attorneys are taking advantage of. And I am sure that you'd want to include those in your plan as well. I'm going to just cover just real quickly estate tax. In Texas, we don't have a death tax. And federally, at least for the balance of 2025, the first 13.99 million is exempt per person. So you can double that for a married couple. If you need to put a plan together to help avoid estate tax, you have a large estate like that, mark that on the form, and we'll put together a plan that addresses that as well. I do want to say again, there's, like I said, 8 billion in our State Department of Unclaimed Property, and most of that got there because someone died and their family overlooked maybe an insurance policy or a bank account, maybe an investment or a retirement account. This could easily happen to you if you do not get financially organized and make sure your family knows what you have in the event of your death or incapacity. Think about it for just a minute and consider, if you didn't make it home tonight, who would know how to find what you have, where it is, and how to access it? What would be lost forever because no one even knows it exists? Take a minute here maybe and jot down a few things that no one even knows exist. Or your significant other doesn't know anything about because you handle all the finances. One that comes to mind real quickly and is new to our world is crypto. And if you don't take the steps to transfer the information as to how to access your crypto, then that is lost forever. But it's not just crypto. It can be bank accounts or retirement accounts, things that your significant other, or perhaps you don't have one and your extended family would have no idea that you even have. Last thing I want to ask you is, if you had to choose between the people you love receiving your money or your values, insights, stories, and experience, what would you choose? Let me put it another way. If you have lost someone close to you, would you prefer being able to hear their goals for you in their voice, stories of their childhood, wisdom, or spiritual goals they had, versus what you receive from them financially? Well, so many estate planners skip this part. And this is where I think the true term legacy comes in. because this is where you pass your legacy on to the next generation. But that is so cherished that, most people would say if they had to choose, they would choose the non-monetary uh, voice from mom or voice from dad or their brother. So it makes no sense that most estate plans just ignore that altogether. You know, a colleague of mine also had this kind of come to mind for him, and that was uh, after his dad passed. All he had, he got his financial inheritance, but he really hung on to this voicemail, and it was short and sweet. It simply said, "Hey Terry, it's Dad. Just wanted to check in on you and see how you's doing, son. Give me a call back." Well, you know where I'm probably going with this, but he listened to that over and over because he wanted to hear his dad's voice. Inadvertently, it got deleted. And that's kind of where this plan comes into play. We put this on video or audio, whatever you choose, and then either save it to a spot on the cloud or put it on a USB drive and have it so that it's available for your family when you pass. So you can basically speak to them and share those things that they so want to hear from you. So we now know what doesn't work. That's doing nothing or having a will only, or even getting an estate plan created maybe by an attorney that just focuses on documents. It doesn't ensure the protection of your kids or your assets, doesn't ensure your assets are owned in the right way, doesn't keep your assets out of court or out of the Department of Unclaimed Property. Very likely could leave your family at risk for just a big mess. For so long, as even in my early days, we would throw a estate plan together. They were kind of cookie cutter style. And we would say, thank you for your business. And that's the last time we talked to you. But if you work with me, one of the things we do is we follow up with you every 3 years and just check in. And here's the other thing. What you need is different than what any other family needs because your family dynamics are unique to you and your family. Your assets are unique. The law as it applies to your family dynamics and your assets are specific to your circumstances. So that takes a specific plan, a customized plan. I will say it's possible maybe a one size plan fits some, or maybe a do it yourself plan could make sense for a few of you. I'll share some thoughts on that in a minute. But for us, that's why we begin all of our planning with what's called a 2 hour. It's a 2 hour working session. Actually, block 2 hours out of my calendar for it. It doesn't always take 2 hours, but it's called a life and legacy planning session. It's a process our clients have come to love, and you will too, because you'll feel so good about your choices after it. You really understand all of your options and actually get your planning done the right way and know you have a plan that works at the right price for you and your family. The life and legacy planning session begins with an inventory of your assets, which you need no matter what you do, what you choose to do. You need one to ensure that when something happens to you, your family knows what there is, where it is, how to find it. Otherwise, those assets are at risk of getting lost and your family left with a mess of trying to find them. So we'll help you and we'll create an inventory of your assets. Then we'll have this 2 hour working meeting that will help you make an informed decision for the people you love. So you know what you actually need to have in place and what you don't. During that meeting, we'll get to know your family dynamics and your assets. You'll get to know enough of the law to choose the right plan for your family at the right budget, so you know you've chosen the most affordable route for you and the people you love. So you're likely wondering what all this costs. The regular cost for a life and legacy planning session is $750. But in a few moments, I'll tell you how to get it free plus a $250 credit towards your planning. Our average fees range from $2,500 to $8,500. It really all depends on your family dynamics, the size of your estate, the complexity of your estate. Are there businesses involved, multi-pieces of real estate? All of that comes out in this working session we have. And by the end of that time to get together, you'll know with certainty you're making the best decision throughout your life, and your family will know how much you cared about and love them in the event of your incapacity or death, because everything will be so well handled. We'll guide you through everything. Ultimately, this is something you do for the people you love, and we've designed the entire process to be as easy as possible for you and to support you to actually do the right thing, that thing that you want to do for yourself and the people you love. Procrastination is the biggest risk to your family, and it's the biggest battle for me most of the time. So here's what we're going to do. If you schedule a life and legacy planning session within the next 3 business days and commit to completing an inventory of what you own and covering some online homework, takes about 20 to 30 minutes before that scheduled appointment, and you turn in that online paperwork, basically you hit submit to us 3 days before your appointment, so I have time to review it. I'll not only waive your life and legacy planning session, but I'll credit you $250 towards any planning that you move forward with. That's $1,000 gift of services and it should inspire you and encourage you to do what you came here to do anyway. So to receive the $250, you must schedule within 3 business days, anytime during the month of January. You don't have to schedule your actual appointment. You don't have to show up for an appointment within the next 3 business days. All you need to do is book your appointment, and you'll book that appointment out 1 to 3 weeks based on my calendar, and then also the time you have to spend to get that online homework completed and sent back into us. So I'll run through it real quick again. Complete the worksheet. You click on the link that's in the chat area, complete that worksheet with your name, address, phone number, and your email. Hit submit on it, and then contact my office and secure an appointment. Use your credit card to secure that appointment. We need a credit card for the simple reason that I have to block out 2 hours of my time for your appointment. Do note you can reschedule up to 72 hours prior to your appointment, and you still be entitled to the $250 credit so long as you reschedule within the month of January. Now, some of you don't actually need to come in and meet with me. So if you're sitting there and wondering whether you really need to contact me to set up a life and legacy planning session or not, let me help you get some clarity about that so you know what to do next. You can create your own legal documents, and you don't need me to do that. You don't need a life and legacy session if you don't have anything that would go through the court process when something happens to you. We'll say you're 100% clear on who you want to handle things for you, and there are no complications. You can list 3 people you want to make healthcare decisions for you, financial decisions for you, and take care of your kids if you have any, and they all live close by and won't fight or argue. Likely you're naturally organized and going to get it done. All you need is to know what to do and you'll do it. And you're not overly concerned about your family going through probate if you get it wrong. If that is you, then there's a variety of resources online. Preparation software, online forms, easy to find. And I don't really need to mention any names. There probably several come to mind right now for you. But moving forward with us, again, all you really need to do is complete that worksheet, hit submit. It'll get sent to me securely, and contact my office and schedule a life and legacy planning session within 72 hours. Like I said, 3 business days. I know we have holidays going on right now. And I'll credit you, I'll both waive the $750 and I'll credit you $250 towards any planning that you do with us. And then use that gift. Make use of your $1,000 gift and ensure a lifetime of protection for you and your family and your wealth, and get excited to complete your homework so that you know your family isn't in the dark about your assets when something happens to you. And sadly, I did say when. There will come a time something will happen, and you can never be too prepared for that. So for any of you that are attending that don't have any questions, thank you so much for attending. I'm going to jump onto I'm going to quit sharing and check the chat, just see what questions there might be, and then I'm going to wrap up. Okay. This was just sent direct to me. I see an interesting question here from Jim, and he says, we have a no nonsense. We're empty nesters. We have a home worth maybe 500,000 now. Way the market's so crazy. And we've both worked going on 30 years and put money aside for retirement and have 2 adult kids. Is a trust really for us? I thought that was just for rich people. Well, I'll tell you this. Rich people use trust, but trusts are for all of us. And a trust provides some flexibility that you really can't obtain in any other way, and allows you that flexibility in how you pass on your property to your loved ones. I would just say that you should investigate it. I meet with clients regularly